right. So we're starting, and I'll clip out the first piece of this. So, hello, my name's Jim Wade. I'm a tax attorney here in Maine, and I am going to be talking about the Thomas Goldstein indictment, which is it's wild, all the accusations. And I thought it was so important to kind of discuss both the civil and the criminal side that in today's episode, I'm just going to be talking about some of the important things that you should understand about criminal aspects of a tax crime. And I have with me William Bly. He is not only a friend, but he's also a well-respected member of the Maine Criminal Defense Bar. Bill, thank you for coming on. I appreciate it.
Nice to see you, Jim. Thanks for having me. Obviously, I'm a criminal defense attorney down in Kennebunk. I practice in both state and federal courts. I do only criminal defense. I've handled my share of white collar fraud cases, tax cases, criminal tax cases on both the state and federal side. So I appreciate the opportunity to jump into this conversation about Mr. Goldstein, and I agree that it's a wild case.
Yeah, and if only Maine could have such interesting cases. I guess for good or bad, Maine is dull.
Well, we
But
have interesting cases, but they're usually around lobsters, not around multi-billion millionaire attorneys, I think.
yeah, well, I guess we'll start with just some of the highlights. So Thomas Goldstein, for those who aren't aware, he is a well-respected, maybe not no longer, but he was a well-respected member of the appellate attorneys who handled cases before the United States Supreme Court. In fact, I think he had either 44 or 45 arguments before, the Supreme Court. But not only that, him and his wife also created SCOTUS blog. For those who don't know what SCOTUS means, that's Supreme Court of the United States. He essentially created a clearinghouse for all things Supreme Court. And before that, you basically had to go to the court or talk to people who were in the know to get any information. So he comes out with this blog. It's so well respected that it actually won a Peabody Award, and I think it was 2012 or 2013. And let's not forget, he was also a very successful business attorney. I'm sorry, ran a very successful law firm. I think, as far as I know, he was making millions of dollars in legal fees for his work. He was handling high stakes security cases as well as class action lawsuits. Um, Interesting to note, I read this, you'll appreciate this. When he first got out of law school, went to work for a law firm, they apparently handled Supreme Court cases. He developed an algorithm to identify cases that were likely to be picked up for Supreme Court review, which, for those who don't know, Supreme Court can pick and choose what cases it takes, unlike other courts. So instrumental in kind of creating this sort of field of studying Supreme Court cases. And then he struck out on his own because they wouldn't let him argue cases before the Supreme Court, said he wasn't old enough. And he actually hit the street and started calling up firms representing clients who he thought their case was going to be picked up by Supreme Court, and built a practice out of it. So interesting character. But behind the scenes, no one was aware that he apparently was an ultra high stakes poker player, a degenerate gambler, I guess. But he was going across the world and playing games for millions of dollars. And unfortunately, both his personal and professional life kind of came together when he was indicted for tax evasion and mortgage fraud.
Can I give you a little bit of
Sure, go
color
ahead.
for the audience? Think in some ways maybe James Bond in Baccarat. He's flying around the world on personal jets, and these poker games oftentimes are being financed by people that aren't in the game. So it could be a $10 million table with four poker players, and you get to buy a stake in Mr. Goldstein, meaning you're going to front it, and if he loses, you're paying the loss, and if he wins, that's how you get your money back. Is based on whether he wins or if he wins. And he was taking out loans over time from they indicate an unnamed billionaire who he signed a loan for. I believe it was for 13, it could have been $14 million
It was, yeah.
on, and he was constantly drawing against it for these losses. It sounds like while he had some big wins, he had a lot of losses. So um, it's not like he was just in mom and dad's basement playing poker for a couple $100. I mean, these are people where like when you hear Michael Jordan playing $50,000 a round of golf, and we as normal people say, "My God, that might be a year's salary for one round," and it wasn't for Michael Jordan. He didn't even have the money to cover these type of games, but he was getting that money fronted, and then he was getting money lent. And this is some of the stuff that Jim will explain that got him into real trouble. But I just want to give you the idea of this was we're talking high stakes poker. We're talking multi million dollar games, things that you and I don't have access to, and if we did, we wouldn't want to be involved anyway.
Yeah. He found himself in a lot of trouble with the gambling. I think in 2016, he had a really great year. I think it was like $16 million. And then after that, it slowly went down and down and down, where winning a much, his pots were much, much smaller and his losses were much larger. Um, in fact, I think, by the end, I think he still owes like $7 million to that business businessman out in California. But games in Hong Kong, Macau, Los Angeles, those are the ones that are mentioned in the indictment. Who knows where else he was playing? But anyways, he was, a world traveler playing high stakes games and living the life, and at the same time running a law firm and arguing cases for the Supreme Court. There's actually a guy who did an article. He knows Thomas Goldstein, where he was tracking his arguments and when he was alleged to be overseas. Apparently, he was burning the candle on both ends in some cases. But there was the indictment was 50 pages long, so I'm going to spare everyone all the details of the various things he's alleged to have done. And let me just put this out there, because we're attorneys. He's innocent until proven guilty. That's the right view for
Absolutely,
everybody.
absolutely.
So everything we're saying here is we are using the allegation, assuming it true for sake of argument, but we're not saying that he is in fact guilty. But the U.S. government is alleging that not only was he not reporting income that he earned, he was essentially redirecting income that he was supposed to report to other parties to pay gambling debts. He was employing people who are alleged to be his intimate partners, according to the indictment, when they did little to no work. He was alleged to have um, trying to figure a way to say this without being so complicated, but he actually had funds in an overseas bank account that he was getting the money back into his firm and disguising the source, saying it was money that was being contributed to the business when in fact it was income. It wasn't real clear from the indictment if it was gambling in earnings or if he had done some legal work and was paid for it. I think some was legal, some was gambling, but regardless, disguising the source of funds, um, lying on a loan application when he was under investigation by the IRS.
Yeah, that generated the mortgage fraud
Yeah, the mortgage
counts.
fraud, because he had tax liens and he was telling the lender, "Hey, I don't have it. I don't owe all this money." He was also apparently getting a litigation finance company to front him money, which he was using to pay off the tax debts. And it's not real clear. It doesn't say in the indictment, but someone mentioned this, that there is some concern that maybe he lied to a lender to get them to pay this off. So, there may be other things out there, but that's kind of the broad strokes. Oh, I'm sorry, and let me not forget willful failure to pay his taxes, where they were saying that he had the ability to pay some or all of his tax debt and instead decided to spend it on luxury items, personal payments, which was their euphemism for paying his girlfriends allegedly, and gambling debts or spending it on gambling. And from reading the indictment, it sounds like the US government has a great deal of information. They reference emails, letters, cryptocurrency transactions that they've been tracing. So they sound like there's a great deal of stuff out there that they use to build their case. So the reason I have Bill here is we're going to kind of talk about this in three different phases. We've got what could Thomas have done before he was indicted? And it's apparent that at some point during this pre-indictment, he became aware of the lawsuit, executed a tolling agreement, and Bill's going to explain what that is, and was working with the government. Then we have indictment. So now he's been indicted. What does he need to consider between that and trial? guilty or innocent, what should he be thinking about? And then sentencing. Again, he's innocent to proven guilty. Everything we're talking about is just assuming that each stage he kind of makes his case worse and talk about what he could do to make it better. So we'll start with sort of the pre-indictment. We have in the indictment, there are some allegations of him lying to IRS agents and maybe even the investigators. There is allegations of evidence tampering or witness tampering because there was something in there about we believe he's been communicating with some of the people in the know and trying to offer them money to change their testimony or maybe to hide or destroy evidence. And
And let me just say that is just you had mentioned Will Rogers. What do you do when you're in a hole? Stop digging. Uh,
yeah,
Man, that is nothing could be more true than that. I mean, the government's investigating you. You're aware that you're the target of a government investigation, that you're probably going to be indicted, and now you're reaching out to potential witnesses to get them to testify or tell the FBI a different story before they've been interviewed, after they've been interviewed. I'm not sure, but I mean, it's bad. I know we're going to talk about things pre-indictment, but I read this indictment, this 50-page. This is just an absolute torching of this guy. Uh, it couldn't be paint like the picture they painted couldn't be any worse. It's just I'd have a heart attack as the defense attorney reading this. But how would we even defend this? I have to imagine things did not go well from a pre-indictment standpoint when they came out with this. This to me, this is when I see something like this, the government is out to smoke my client, and things did not go well. The government has the power pre-indictment to decide what charges are going to be brought. Okay, and there may be an opportunity to negotiate. I will tell you this: once the U.S. Attorney's Office is involved at this level, the train has left the station. It is unlikely that you're going to do anything to prevent the indictment. What you can do, though, potentially, is negotiate what the indictment looks like. But this is a blistering indictment. It's just not something I've ever, in my practice, ever seen at all, whether it's a drug case, a white collar crime. I mean, of course, you have a high profile person, a member of the bar who's handled cases before the U.S. Supreme Court, and not just an attorney, but a very sophisticated attorney who deals with,
yeah.
has done security transactions, understands what security frauds are, understands what fraud is, and knows what he's doing is not just circumventing the law, but blatantly jumping across that threshold into criminal conduct and seemingly not caring. So I have to imagine that while there was a tolling agreement, which that means the government is, you have a statute of limitations as to, from a time period that you can go back X amount of years. The government will sometimes seek a tolling agreement. I've seen this, and oftentimes it's usually in the defendant's best interest to agree to a tolling agreement. Why? Because it keeps us talking with the U.S. Attorney's Office versus them just saying, okay, we're going right to indictment. And you don't know what they're going to blast you with. And you lose that opportunity, that window of time to talk. So if you keep if you toll that time, it gives you more opportunity to speak with the U.S. Attorney's Office and maybe negotiate something better. I have to imagine things went really askew and south during that time period. He must have been doing other things while he was under investigation, like reaching out to witnesses, like moving money, like still, doing the things that he's accused of, doing more fraudulent transactions, whatever that may look like. Probably lied to investigators, all of which is just going to make the U.S. attorney angry. And now you're the focus. Now you're the focus of their ire, and this is what you get: a 50-page indictment. Again, as a defense attorney, I'd have a heart attack saying this. I mean, it is just, if I was the person accused of this, I'd probably want to jump off a bridge. It is anxiety provoking. I can't imagine being the defendant seeing this.
It's
Uh,
almost as if they took a certain glee writing this.
I mean, and it's well written, it's interesting, but it is blistering. It just portrays this man in the worst light. And it's, I read
How hard.
this, I read this, I'm worried. I'm worried if I'm the defense attorney. I'll just keep it at that. Like, how in the world are we going to defend this? And
You start,
that's the
start
thing.
really
When the
considering
government,
plea
yeah,
negotiations.
like the government, when they get involved, they basically already built their case. They've been investigating. It's like they just started an investigation. This isn't the state side. They just started an investigation a few months ago and then they indict you. This is a complex tax evasion case with payroll fraud. It's there's a lot to it. So they've been investigating this for quite some time. So they lined up all their ducks before they even sent a target letter out to Mr. Goldstein. And then Mr. Goldstein has a chance to maybe fly straight and doesn't even do so. I mean, I'm assuming.
Yeah.
Again, I'm not part of those conversations. So, what can you do pre indictment? First thing is don't make false statements to federal agents. It's a crime. And they're going to charge you separately for that crime for making false statements. When the FBI asks you questions, that's where you should at that point be. The moment you got a target letter, you should be talking to two people, a criminal defense attorney and a tax attorney. Why? Because you need to have confidentiality. You don't have confidentiality with QuickBooks. You don't have confidentiality with your bookkeeper, with your
Yep.
CPA. You have attorney client privilege and full confidentiality with your legal team. That means a tax attorney and a criminal defense attorney. So at the very least, you need to be having very frank, transparent conversations about what the heck it is you've done, what you're worried about the government's going to find out about, so that your legal team, the tax attorney and the criminal defense team, can figure out what, if any, way through this we can pick a path here. Otherwise, you're just creating more problems for yourself.
Now, actually, that brings up an interesting point. This may be not relevant to Thomas Goldstein, but let's say client suddenly gets finds religion and says, you know what, I should probably, I've done wrong, but I want to get ahead of this. Would it also make sense to engage a criminal defense attorney to help craft? You suspect the IRS is going to discover your case down the road. You kind of see it coming. Let's say you were engaged in cryptocurrency transactions and you suspect that they've got your records as to that.
And they
Uh,
probably do.
getting an attorney to essentially create something like a packet of materials and then come forward to the government before the government comes after you.
So oftentimes, when I've dealt with cases like this, you have a number of different stakeholders. You have you have the IRS and you have the U.S. Attorney's Office. The IRS wants their money. The U.S. Attorney's Office is trying to negotiate if it's a plea with the defense attorney, but you're also not in the room with you, but is putting pressure on the U.S. Attorney's Office is the federal government in the form of the IRS. They want these counts in there because they want to be able to have you plead guilty, so then you're on the hook for those tax amounts. I think there is some advantage from a sentencing standpoint. If you think the case is going to trial, you certainly don't do this. But from a sentencing standpoint, maybe filing amended returns before the indictment comes down and alerting the government to it and saying this is based on the information we have. We've filed an amended return. Yes, it's an admission so that they can use that against you. But from a sentencing standpoint, you're at least showing the judge that you are now you understand what you've been charged with, and now you're trying to set a better foot forward. I think there's some power there for sentencing, but certainly does not help you from a trial perspective. That would hurt you.
Gotcha. Yeah, because it's essentially, like I said, an admission. You were
Yeah,
declaring that what was done first was wrong, and
right.
maybe blatantly so.
Right, because here's the thing: you filed. Let's just say you said your income was $500,000, but like Mr. Goldstein, you left off what I forget, it was $13 million, some crazy numbers. I think it was 3.5 million.
It was 3.8 million on 2016 that went
Okay,
to.
so yeah, I declared 500,000, but really it's 4.3 million, and I'm going to pay the taxes on that because I have the penalty for underreporting. I have a few penalties that I'm now going to have to pay. One of, at the very least, is the failure to the failure to file it accurately, the underreporting, and I'll make those payments up front. You basically, by filing that, I think that gets to be used against you as an admission. But again, from a sentencing standpoint, you can show a judge, and I've taken the steps to so the government doesn't have to prove this. I recognize why this is wrong. Once I realized the scope of this, I just needed to come clean and try and show the court that I'm worthy of a second chance. Basically, it's a sentencing
Leaching out the
mitigation
poison.
issue.
Essentially,
Yeah,
leaching out some of the poison.
yeah,
It's still there, but at least you could get some of it out.
yes.
Um, I think that's about it for the pre-investigation. I mean, don't lie, don't continue to engage in the same bad acts. It does look like he did clean up the amounts that were owed for the prior years, he did appear to have paid those off before indictment, or at least,
I-
yeah, he
And
made
that was and
indictment.
that was and that was a good move, but it sounds like he compounded it with also trying to not just tamper with witnesses, but I think there was some allegation in there about destruction of evidence.
Yeah, yeah, that didn't help.
So, I mean, those things are all so very bad. I mean, they go to it, they go to form an intent. When you then try, it makes it's so hard for your defense attorney to talk about acceptance of responsibility after the case. You may have lost any chance for acceptance of responsibility. And I just maybe just want to touch on this, like how does sentencing, without getting too deep into sentencing,
Yeah, yeah.
just talk about something that's important. When you're charged with a crime in federal court, there's a point system, okay, and a tiered system. Uh, you have a criminal history. You get point categorization based on criminal history. Assuming Mr. Goldstein has no category, no historical, no criminal history. Let's call him he's a criminal history of zero. That's in his favor. But all these charges that are stacking up have points, and the higher the points go, even in a criminal history of zero, you start looking at prison time. And the higher the points, the greater bracket of prison time is. So the more points, the more prison time you're looking at. One of the things you can do to reduce that prison time is early notification of plea and an acceptance responsibility. Based on his conduct, the court may not allow him to just maybe they'll allow notification of plea, but his conduct was so willful to cover this up that the court may not accept. Say they may find that we don't find that you've accepted responsibility and you lose 2 points. And that may not sound like a lot. It's a huge difference from a sentencing standpoint. That 2 points can make the difference between you being in prison for 7 years. And I haven't done a calculation guideline sentencing calculation of this guy in 3 years. I mean, it's a big difference. So he's
A
looking at
year's an
that
awful
too.
long time.
Yeah, think about the value of your life. Like, what is your life worth? People don't think about that. They think about, well, how much money am I going to pay? What does it matter when you got to sit in a prison cell and you think I could have shaved 2 more years off? Why didn't I come up with that 50 grand the attorney wanted? I could have been out. I could be out 2 years from now, but no, I got to sit here the other 2 years. I mean, that's really what you're looking at. It's your life behind bars. Anything you can do to shave time off is important.
Yeah, I know there's a Eric Green. He's a tax attorney. He does criminal and civil. I know he says whenever he has a criminal case, he goes to the whiteboard and writes freedom and money. Says you got to have it's one of the it's one or the other. It's not both. So I'm focused on your freedom and not on your money. So because if you need to hire experts, if you need to engage a very good defense attorney who knows white collar crime, tax crimes, so it all makes sense.
Absolutely.
Um, Oh, I was going to say, one of the questions I have is when you engage a criminal defense attorney during the investigative phase before indictment, um, as far as the advantages of having that, I'm assuming you're going to back me up on this, is generally speaking, you're going to help them understand what they should do and not do to at least avoid the indictment or reduce it down as little to as the least amount of pain possible. Um, pay your taxes, file the correct returns, don't lie, don't talk to anybody. Um, I'm sure there's some other things out there I'm forgetting that just from doing it, but there's some reason to do that to give you some guidance.
Yeah, but also I want to be able to have a conversation with the U.S. Attorney's Office about the case and about the charges because there is an opportunity to negotiate the charges. Like clearly this is the conduct was so egregious and things must have gone south during that pre-indictment phase. That he gets his 50-page indictment. That's not usually how it plays out. When you get a target letter from the government, what they're saying is we haven't charged you, but we believe you've committed a crime and you are now the focus of this investigation. You have an opportunity at that point to come forward and talk with the government about what you've done, and maybe save them some time. That in some cases, that's a possibility. This is not the type of case, usually you don't see this on tax fraud, right? This is not the type of case that you're likely going to be a cooperator on. You're the one that's been committing
Yeah.
all the crimes. But say in drug cases, all the time we want, if the government usually has a good case, what do we want? We want our clients, if they can and they're willing to go up front, do a proffer with the government, which is an agreement to talk about cooperation if you give us what we're looking for and we think it's valuable. And then maybe you cooperate, you're getting massive time off in your end sentence. This, it doesn't sound like there's any Confederates involved. It just sounds like all conduct by Mr. Goldstein. So that's not something that would be of use. But if it's a white collar case and there are other Confederates involved, say it's a securities fraud case and there are other people involved, that might be an opportunity for you to immediately talk with the government and then maybe get a cooperation agreement. But again, in a tax fraud case, it's usually you. There's not going to be cooperation. The government might consider again you sitting down and doing what's called a proffer to lay everything out, but you better be damn truthful. And maybe they'll go a little bit more lenient on you because they don't have to do all the heavy lifting at that.
Yeah. So unless he's engaged in some tax fraud with other parties, like helping them hide, legitimate income, he's probably on his own for this case.
Yeah, I think so. It doesn't sound like anybody else is involved.
Yeah, which is a good segue to the next stage, which is you've done put your foot in it. Now you've been indicted. When someone is indicted, I'm assuming it doesn't come out like a bolt of lightning out of the sky, that usually there is something that leads up to it, at which point now you know you've been indicted, and then things start happening. Could you tell us a little bit about what that's like? Because being a civil tax attorney, I've never had the pleasure of witnessing happen. I hope I never do, but I'm sure you know from your clients' experiences.
So it doesn't come out of nowhere, and this is why you get the attorney involved in the beginning because you've already been having conversations with the U.S. attorney. I mean, one of the things you're talking about is, are you looking for bail on this client? If so, can we discuss what bail might look like? Do we need to get him screened by U.S. probation to see if the idea in the federal system is that you are automatically entitled to essentially PR bail, unless you are a flight risk, which Mr. Goldstein might be with his financial means. I think the government would likely make a good argument on that, or a danger to the community, which can be construed in a number of ways, but you see those in potential sex cases and drug cases. But if somebody is a potential danger to the community, for example, a sex case, that's something you can negotiate with the government about saying we're not going to argue that because your client has been cooperating. So if you're involved in the pre-indictment process, you already know what the charges are going to be. I don't know that this attorney knew that to the extent that this indictment would look. Probably not. He was probably taken by surprise
I think so.
to a large degree. My guess is his client probably wasn't fully honest with him about everything either. And the government doesn't like to be lied to. So if they're going to come, if you've been lying to the government, maybe it does come out like a bolt of lightning out of the sky. But if you have a good criminal defense attorney and you're smart, you're going to talk with your attorney, you're going to be honest with your attorney, so your attorney can negotiate these things so it's not a bolt of lightning coming out of the sky and you're being arrested, and taken before a magistrate and then arguing bail that may or may not be sent.
Yeah.
And by the way, here's something else. Mr. Goldstein could have negotiated his pre-trial release in advance with an agreement to turn over, say, his U.S. passport, so he can't leave the country. That's something that you want to probably negotiate in advance versus trying to argue it to a U.S. magistrate at a bail hearing.
Don't want to call it kabuki theater, but usually get everything set up so where it's not like you have an agent knocking on your door first thing on a Monday morning, arresting you while you're still in your bed outfit, whether it be robe and slippers or, whitey tighties.
Right.
So,
And you don't usually see that on white collar cases because yes, they may be a flight risk, but again, usually the attorney's involved. There's discussions with the government. The government has some level of confidence that the client isn't going to be a flight risk because they've got the attorney involved.
but now that he's been indicted, though, it's not like you can let your hair down. There's still things that you can really do to screw your case up. And it sounds like further allegations of talking to witnesses, maybe trying to conceal assets, maybe even destroy evidence.
How about represent yourself at
Yes.
that point? I can't imagine. Abraham Lincoln said, "Those who represent themselves have a fool for a client." I couldn't agree more.
Yep.
Uh, the worst thing you can do at this point, I mean, you're an attorney. This guy is obviously incredibly intelligent. He also has a big ego. You don't represent yourself unless you think you're smarter than the guy that you were going to hire to represent you. He must not have a lot of respect for the person he got involved or didn't get involved at that point. But the fact that he's representing them pro se, you have to be careful. yes, you're representing yourself, but you're also the one under indictment. So the statements you make can be used against you later on. You're making statements in court as the defendant. Just because you're an attorney representing yourself doesn't mean that you get to walk away and say outlandish things that can't be used against you later. So
Yeah,
that's probably one of the worst things he could have done was go pro se on this. I cannot understand the rationale for that. He could certainly afford the best representation, and he didn't. At least at this stage, I don't know if things have changed, but at least for a period of time, he didn't do that. And then, as you
yeah,
indicated, just shooting himself repeatedly in the foot, reaching out to witnesses, trying to tamper with or destroy evidence. You mentioned earlier when we were speaking before we were on camera that he was brought up on a bail violation for conducting more cryptocurrency transactions, but
yeah,
the government had to prove to the presiding judge in order to revoke his bail by clear and convincing evidence that he had engaged in these transactions. And based on the representation, so at least at this point, he was smart enough to have his criminal defense team involved. They made an argument to have the judge think, well, I don't see clear and convincing evidence. I think you did it, but I don't have the clear and convincing evidence I believe necessary in order to revoke your bail and have you held. So I'm going to let you go. That stuff is just going to add up against them later, whether they bring that into the indictment as a separate, a superseding indictment that they can bring later, or they just charge it as relevant conduct at the end of the day. This is all stuff that goes against him as willful disregard for the law. And I think this just paints a very bad picture for him when he's looking at sentencing down the line. I mean,
yeah.
again, I've read through this and I don't know enough about the case. Clearly, I have no inside information. I haven't seen any evidence, but I mean, it's terrible. It reads like a almost like a fiction novel. Like, how could this be so true? It's
Well, and
crazy.
it's yeah, and I think what's interesting about it is he is very smart, but he almost seems like he wants to make it worse. Sometimes people with
Well,
really big brains, they unfortunately can't see the forest for the trees. I
I,
think I wonder
I
if the pro se was um, he was arguing that he was broke. Said, I'm in debt to 3.3 million, sorry, to the tune of 3.3 million. I need to get funds from my house because I need to hire counsel. I wonder, I'm not saying it whether truthful or not, I wonder if that may be what he was trying to show was, hey, I'm broke. I need an attorney. Let me get this money. Was it a good idea? Probably not, but I wonder if that might be why he did that, went that way.
yeah, I don't know. I can't think of any reason. When I've represented really smart people that question my legal knowledge and then start bringing up other hypotheticals and what about this case and what about that case, that tells me that this person thinks they're smarter than me, and maybe they are, but you're not smarter than me when it comes to this area of the law. I always give my clients a lot of benefit of the doubt. I never think I'm the smartest person in the room by far, but I do certainly know more about the law than any of my clients ever have and probably ever will. And trying to tell your attorney, tell them how they should run the case defense is just, it's a good way to damage the relationship and also shows that you don't really get what's going on, which is this is not your area of expertise. Now, Mr. Goldstein, he seems to be the exception. Why? Because he's a very well-regarded appellate attorney. He probably does know the ins and outs. But again, you've got to put trust in your defense team. It's good to have input. It's not good to try and run the show.
Yeah, I was going to ask you about that. Is you've probably dealt with some clients who had fairly large egos. Do you have to almost take them to the woodshed and said, look, I know you're smart. You're probably way smarter than me, but in this area of law, I am the expert. You need to sit back, relax, and let me do my job. You're going to be, right now it seems strange, but 6 months, a year from now, you're going to go, thank God I listened to, Bill Bly.
Sometimes it's a very delicate balance between you being confrontational and then maybe damaging the attorney client relationship. Like there needs to be a level of trust. And as an attorney, I'm always very sensitive to not damaging that level of trust. But if it's become apparent that the client doesn't trust what I'm saying, always arguing, always pushing back, at a certain point, I'm not going to fight you. I'm just going to say, look, it's clear you don't trust what I'm saying. I think at this point, I'm going to enter my withdrawal. You should find another attorney. But I mean, It's like when we ask clients to provide us with documents and they give us excuses why they can't get the documents. It's like, I can't advocate for you when I need these documents to be able to show as proof, whatever the defense is, and you just keep not giving them to me. Like, it's not allowing me to do my job. So if you're not going to participate, if you're going to be a roadblock versus a meaningful participant, I won't represent you.
And I think this
Someone
cuts
else can deal
across,
with it and take your money.
yeah, I think it cuts across all legal specialties, which is if you are a client and listening to both of us here, because you hire an attorney does not make us magically able to just take your case and wave a wand and it all done. You have to participate and provide the evidence, the ammunition, as it were, to defend you. If you don't do it, there's nothing we can do. I think I've had some people come to me and they almost expect that by hiring an attorney that I somehow know all the inner workings and I know who to talk to, whose elbow to grease, and magically it's going to disappear like all those attorneys on TV
Yep.
or in the
I get
movies.
that frequently too, Jim. And it for the folks listening out there, I get a lot of I've paid you all this money. That's probably the worst thing you can say to me. Because to me, then I'd be kind of offended. Like, you've been if you're always saying I paid you all this money, the only thing you cared about is the money you spent, and you're not valuing the work we're doing. And to me, that's when I start hearing that, it's like, okay, it's time for us to part ways because you just keep questioning everything, and it's all about money. The other thing that is problematic is when you're trying to tell me to do something that is a violation of the bar rules, is unethical. You want me to lie for you. I'm not doing that. Just like I'm not advising you how to break the law. I'm sorry. That is not my job. In fact, that could cost me my bar license, and I'm not doing that for anyone, and no attorney should.
Yeah.
We're not going to engage in fraud in order to defend you. We're not going to commit a fraud upon the court. We're not going to allow you to perjure yourself if you chose to give testimony. In fact, we would have to alert the court that you provided perjured testimony. These are things that when I start getting clients trying to pressure me into these things, I fire you. That's it. That is not the attorney you've hired. You've hired someone, and the other thing is, I actually don't work for you. You're not my boss. You've hired me, but I'm neither your servant, your slave, nor your employee. It's important for clients to remember that. This is a respectful relationship. It doesn't mean you get to order me and my staff around. When you do, you get fired.
Yeah.
And I would imagine most attorneys have a threshold where you pass that threshold, you're gone too.
Yeah.
So, and people think because they've given you a payment that now they essentially own you. And that's really not how it works.
It's probably the worst thing you can do because then you're not listening. I
Yeah.
think when you're
You're just
talking to
dictating
clients,
what you think I should be doing.
because I've had clients where you talk to them about something and most of it they don't know what you said, but they're always, they're more focused on the result than listening to what you're trying to do to help them get the result they want.
Right. Or
Like
they're
you
talking
said,
to their friends or their
wow.
neighbors who said, well, I heard about this case and my cousin got this deal. And
Yeah.
why am I getting this deal? I got a client in court the other day who said, well, I heard that person, they got a better deal than me. I'm like, they may have, but I don't know why they got that deal. It's not my client. If it was, I couldn't tell you anyway. And I'm sure other attorneys been on the other side when my clients have gotten great deals and their clients are like, why am I not getting this deal? Because everybody's case is different. We can't just base it on, it's not a cookie cutter system where if you committed X, you get X as the outcome. That's where advocacy comes into play. And in individual characteristics of the defendant, the client come into play too, and their personal circumstances play a big role in sentencing,
And they should
which
be happy about
gets
that.
us back to Mr. Goldstein, who has everything working against him for his background when it comes to sentencing.
Yeah, because he's a professional. He can't argue that he didn't know any better.
No, no.
Or
Not only is he a professional, but he has an insider's track to how the legal system works. It is not his first foray. He's a well-regarded member of the bar, a very well-respected appellate attorney who's argued 28 cases before the U.S. Supreme Court. A very sophisticated. There are different levels of attorneys, right? Different levels of
yeah,
sophistication. I would put Mr. Goldstein at the top of sophistication for attorneys, and that works against him. The I didn't realize it, or I didn't understand, or I was having a tough time isn't going to cut it because we're talking millions of dollars. I mean, I just don't see how he gets out from underneath it. It's a Herculean effort and a long shot from what I've seen.
yeah. I would think if he was trying to argue, let's just say, for example, he was trying to argue he was operating under some sort of disability, alcohol, drugs, what have you. Um, if he's at the same time arguing before the Supreme Court, you are going to have a hell of a time getting anybody to believe you. They're going
Right.
to say if you could argue before the Supreme Court, you could have taken care of this, or you could have taken the right steps to do,
Right.
everything. You can't.
And this was an ongoing thing over the period of years. So at any point, you could have gotten off the train, stopped the train, and taken action to turn things around. The only reason you stopped the train is because the government stopped it for you. They forced you off the train. That's Yeah.
Yep.
I mean, a lot of the arguments you can make as a defendant, a lot of times, we're not dealing with people with this type of money. We're dealing with, middle class people, maybe upper class people, but not to this level of fraud. But acceptance of responsibility and an explanation is really important to the court. I don't know, doesn't cut it. Or and maybe I can address sentencing issues if you'd like, Jim, when we get to sentencing. So I have some things to say about that people should be
Good
aware of.
segue. We'll get to that next.
Okay.
Let's finish your thought.
Uh, well, the thought is, I think we should talk a little bit about things that can cut against you in sentencing, beyond Mr. Goldstein, but things to be aware of, and what sentencing looks like and what you have to be prepared for.
Yeah, I mean, so I think we've pretty much mined all we can about the indictment. It's basically have an attorney to represent you, don't represent yourself. Make sure you're listening to your attorney as to what to do and what not to do. Actually, I should have mentioned this because it just came to mind, but I think it's important to point out social media is not your friend once you've been indicted. You should say nothing.
Nothing. You should shut your social media down, but the problem is they can just go back in time. I'll give you the
Yeah.
classic example. There's a case, this was like in South Carolina or Virginia. It was a number of years ago, but I'll never forget it. Kid was indicted for manslaughter, killed his best friend in a drunk driving accident. I know this is not a white collar crime, but this is where social media gets you. He's out on bail, PR bail. It's a state case. The parents of the boy, of the best friend, don't even want him to go to prison because he was like a member of their family too.
Yeah.
Well, he posted on social media, took it down later, but the government got a hold of it. He was at a party, Halloween, drinking alcohol, dressed as a prisoner. Think about the optics of that. The lack of remorse and acceptance of responsibility and making light of your own situation by, number one, you can't have alcohol. You're chugging beers out of, it's all the red Solo cups, and
Yeah.
you're dressed as a prisoner. Like, that's funny. You killed your best friend. That kid got hammered by the judge. Didn't matter what the other family wanted. The other family was upset at that point. But the judge went well above and beyond, I think, what the government was looking for. And that was a big aggravator. So, yeah, it's important not to get on social media, not to say anything. You have to assume anything you've ever said or will say can be picked up by the government, will be used against you. It'll never put you in a good light.
Yeah. Don't destroy these social media, whatever you've
Right.
posted. Don't
Just
post
shut it
on it.
down.
Shut it down.
Yeah. And I honestly, I never see any value of social media ever. It's just somebody talking about how bad their life is or how great their life is. And we all know it's phony anyway. Like, you see your neighbor and they're posting all these great pictures and what a great life they have. And you're like, that's not the person I see on a regular basis. They're usually pissed off, but now they're talking about how great their husband is, but they're usually telling me how much they hate their husband. Social media is it's just a big phony, pretend this is what my life looks like. I don't know why people participate, but on the criminal setting, I can't tell you how many times I've seen it used against clients. It can be incredibly damaging, and it's a gold mine for the government to look through and use against you.
Yeah. I'm always afraid of clients going on social media to bellyache about how wrong the government's doing them. And it's like, yeah, you're not doing yourself any favors.
No.
But I think we've pretty much mined what we need to on, indictment.
The one thing
Oh,
I'll say about the indictment, because we are leaping forward from indictment to sentencing. Obviously, there's a big part in the middle that goes, and I'll just touch on, you have trial. This is assuming that either you went to trial and lost, or you just went to a plea, and also an opportunity that brings a motion to suppress evidence, maybe evidence that was obtained illegally in violation of your constitutional rights, usually Fourth, Fifth, or Sixth Amendment. I don't want to go in there because really with the Goldstein case, this has really just gotten started. This case could go to trial. There could be major motions. I would expect the defense to be filing major motions with trying to keep out certain portions of evidence to try and maybe cut down on what's in the indictment, what can be then used against him in trial. But that is a part of it. We're just going to sentencing because in the federal system, the vast majority of cases don't go to trial. When the federal government's involved at this stage, it's like a 98% plus, depending on the jurisdiction you're in, but Maine, it's like a 98% conviction rate. You lose, you stand to lose more than you do gain, even when even when you're facing serious charges by going to trial. You better have a damn good defense that you've got more than just a coin flip chance in your attorney's estimation of winning, because you stand to lose a lot more when it comes to sentencing. If you didn't accept responsibility, give the government early notification of plea, you go to trial, you've lost all that, and
Yeah.
now you're going to sentencing and you're going in a much higher category.
Yeah, and I think there was one of the motions I read. I think there's 50,000 pages of documents. You know,
Oh,
there's chests of stuff that they've brought. I know, innocent until proven guilty, but it seems like they at least seem like they're bringing the goods on this case. And so what you're saying is he really should be thinking about a plea, because if he goes to trial and he gets smoked, he is going to have a tough time at sentencing.
yeah, and here's the other thing about in federal court. If there are cooperators, you might get a report, and some of it may be redacted, and you won't know who the identity of that person is until after they testify. Or you might not be given a report from that cooperator until right before they testify. So you basically have no time to prep. Federal court is very different when it comes to disclosure of discovery. The government will disclose what it thinks it has to disclose. Uh, and I'm blanking on the name of the I'm blanking on the name of that, and it'll come to me later.
You know,
Uh,
Brady or
no, no, it's not even Brady Giglio stuff. They have to turn that over. It's about information that they don't have to provide until literally the day of trial, and it's usually has to do with cooperator material. That you don't get that until like literally the day of trial. So if somebody in Goldstein's firm is cooperating and helping, they may not even be aware of it, and they go to trial and then they get basically sandbagged with it, and that's one of the risks you run in federal court too. So trial is it's filled with a lot of landmines. You don't make the decision to go to trial lightly, because again, you stand to lose. I mean, obviously, if you win, you walk away. But with this number of counts, I just see it fraught
I
with
mean,
danger.
what would you expect a time? I mean, how long a trial like this might last? We're talking a couple months, right?
Potentially, yeah. And when you're talking 50,000 pages of documents, and that's what the government will just deluge you with this stuff. It's not a single criminal defense attorney, where you got to have a firm, like a whole firm, a team of like, and
Yeah.
they're just dedicated. All they're doing is working on your case. Why? Because they've got to go through all of this mine of information that's been dumped upon them by the federal government. One person can't do it. You probably got a team of 5 different attorneys and all the paralegals sorting through the stuff, trying to make sense of it, categorizing it. How's it fit into the defense? How's it fit into the prosecution? Is it admissible? Working through the evidentiary issues. I mean, it's just a total nightmare. I mean, a case of this scale and scope, you can't. There's no way you're going to have a single attorney working it. That means you're paying that law firm thousands of dollars an hour for them to work on that case. I mean, it's probably a multi-million-dollar defense. You better have the
I
funds.
say. I was trying to guess in my mind because we're not dealing with Maine attorneys. We're talking DC attorneys.
Yeah,
Sure,
white
they
shoe,
charge three,
yeah,
four
these are
times the
former
charge.
U.S. attorneys now on the defense side, right? They've done these type of federal civil prosecutions, these white collar prosecutions. They did it for 15, 20 years, and now they're paying a very handsome fund or fee to work at these law firms to now work for the defense. You're going to have their federal pension for being a U.S. attorney. They've got all the inside information, and you're probably paying that one attorney well over $1,000 an hour, probably somewhere around 1,500 to $2,000 an hour is my guess from DC.
Feel a little jealous. You're like, yeah, there'd be some good money
It
to
is
have.
expensive to live down there, Jim. I mean,
Oh, I
honestly,
know, I know.
not that it's cheap to live in Maine either these days.
Especially York County, which is, Massachusetts North at this point.
That's right.
So yeah, let's switch over to sentencing. So let's assume whether it be plea or trial, they find against him. He now is humbled, and now he has to make an argument as to why he should not spend a significant amount of time in jail. Um, Yeah, I know it's the default isn't, I'm sorry. I know not necessarily will he have to go to jail, but
Oh, he's going to prison if he's
he's good. I'm
if
sorry,
this
I used the wrong
shakes
word.
out, he's going
Prison.
to federal prison.
Yeah, but likely he is going to spend significant prison time. But
Yes.
why then is it a good idea to have a criminal defense attorney at sentencing? Because I think most people think that up to trial you need an attorney, but at sentencing, all right, well, we already found me guilty. I mean, what more can I do? You just throw me in front of the judge. Say I'm sorry, and we move on. But there
Here's
actually is an
here
art and a
here
science to it.
Yeah, there is, and it starts with the pre-sentence investigation. So you've indicated you've put so you it really starts with the plea, or you were found guilty. But let's just assume this ends up being a plea, and Mr. Goldstein or whomever the client is pleads to X, whatever the charges are, or what were negotiated for the plea, and that's what the court will start with. In most cases, the court will allow you to remain on bond, so you can remain in the community, remain working, hopefully. At this point, Mr. Goldstein would probably, his bar license, I would imagine, is in jeopardy, if not flat out loss. When you commit tax fraud, that's almost a guaranteed death knell for with the bar for your bar license. So I would imagine if that's what he pleads to, his bar license will, if not be suspended permanently, it could be at least temporarily for a period of time. But then there's a pre-sentence investigation, and that is where you have to really be careful. What you say in a pre-sentence investigation to a U.S. probation officer who's compiling what's called a pre-sentence report is going to be in that report. And if you then try and during argument raise things that are contradictory to what's agreed to in the pre-sentence report, that's going to raise real red flags for the court, and it's going to piss off the U.S. attorney, and it's going to result in a separate hearing on the issues you've raised if they are outside of what was basically you've said in the pre-sentence report. So, for example, using I had a problem with alcohol or drugs, and that was never, it was in the pre-sentence report. No, I never had this issue. And suddenly your attorney is making this argument about how you struggled for years in and out of rehab with alcohol and drugs. The train's going to come to a screeching halt, and you're going to have to now prove that that is the case. And why wasn't it in the pre-sentence report? Because you don't just get to surprise the other side. The idea of the pre-sentence report is that both sides understand the factual background and the basis for the plea, and there's all of these different areas that the probation is going to look into. Did you have a drug and alcohol problem? Did you have a tough time being raised as a kid? How did that affect you? What was your criminal history, and how could that have impacted things? Because they're looking at potential mitigation and aggravating components. And the idea is that this pre-sentence report is going to be for the judge, and the probation officer will ultimately calculate, they won't tell you or the U.S. attorney, but they'll calculate the pre-sentence or the guideline sentence that should be applied in your case, which is a range of months or years. That should, based on your criminal history and your final offense level, that's calculated by probation. You can argue in that pre-sentence report or object to certain portions that if you think the probation officer got wrong, you object to it, lay the basis for your objection. You may need to have a hearing on it, or both parties in the court may agree. We can make that change by agreement. You may want to have additional things added that should have been in there before the final pre-sentence report was completed. Now it needs to be amended. All the parties are on notice to it. So you want to make sure your client is not shooting himself in the foot in saying things in that pre-sentence report that he might decide to contradict later, because that will definitely hurt him in sentencing. You could lose acceptance of responsibility if you start making excuses for your conduct that weren't actually in the pre-sentence report and given to both parties. So that is, when it comes to sentencing, that ends up in most cases for the defense attorney, the most important part you can do. That's where advocacy comes into play. That's where you're making an oral and written submission in argument form. You've got the pre-sentence report, you've massaged it in the way that you can, and now you have to tell your client's story, referring to the important facts of the pre-sentence report to explain to the judge why your client should be given a little bit more mercy than maybe what the guideline sentencing would normally require. If it's an alcohol or drug related issue, you're arguing that pretty heavily for the court to do what's called a departure. So you have variant sentences and departures I won't get into the differences because they can
Yeah.
confuse even seasoned attorneys, but you're arguing for reasons for the court to depart from the guidelines. In the past, the 1990s and early 2000s, the court was required to follow. You didn't matter unless you could show a statutory reason for why the court could vary from the guideline sentence. Whatever the guideline sentence were, you could argue within that guideline, that little bracket of time, but you couldn't
Yeah.
argue outside of that. And now that the guideline sentences, and they haven't been found to be required to be followed for well over a decade now, but courts still need to put on the record why they're going to depart from it. And you want to give the court reasons to depart from that guideline sentence, because that means getting your client's uh, sentence lower. But you have to be very careful when you argue that you don't argue things that are contradictory to what's in that pre-sentence report, because you will be called on the carpet as the attorney and your client will pay the ultimate price,
Yeah. You
because you're
definitely.
representing to the court what your client, basically you're saying to the court, this is true and this is my client's life. And if you're putting bullshit out there, man, it's going to blow up in your face. You'll be embarrassed as the attorney, and your client's going to be getting whacked on sentencing. So you got to be very careful. You don't want to just put your client out there to make some statement. You want to make sure that if your client's given a statement of contrition, that you vetted it. I would never allow a client to get up in front of a federal judge and just speak spontaneously. That could be nothing but a disaster. You want them to read from a crafted script. You want it to be the client's own statement, but you want to make sure that you've reviewed it to make sure that he doesn't put anything crazy in there. He doesn't, and he understands, don't go off the reservation. This is what you're confined to. And the court can ask your client questions if they have questions. And now your client's going to be put between the rock and the hard place. Do I answer that question? Does it make me look bad? Does counsel step in? So there still are landmines even during sentencing that could blow up. And I've seen it, and I've had it blow up in my face with clients in the past that weren't prepared to answer some. These judges are the best of the best. Don't think for a minute
Yes.
that these federal judges are dumb. They are not. They are usually by far the smartest person in the room. They have seen it all. They are incredibly razor sharp, insightful, and they want to cut right to the heart of the matter. And you better be prepared to put together a good argument. And you can bet your behind that if you put an argument on paper to the court, they've looked at your argument upside down, backwards and forwards, and really taken a look at the case law that you've submitted, and they will call BS on you in a heartbeat if it's a stretch of the legal truth. Let's just keep it
I,
that way.
I've never run afoul of them, but I've known them. I've seen them. I used to go to the federal court and watch federal proceedings during law school, and I've seen some things. I was like, those guys, no slouches.
I will say every time I get into federal court, it's like a nightmare. It if you're not there every day practicing, it's like being on the moon without a space helmet. Like there's no oxygen. It doesn't look like planet Earth. Everything's different. It's because the rules of federal court and how they go about things are very different than how they are done in state court. In some ways, state court almost feels informal compared to the federal court system. In the federal
Yeah.
court system, when you get in front of a judge here in the state of Maine, they are elevated way above you. They're looking down on you. It's the idea of the way they set a federal court up is to impress upon you the formality, the seriousness that this is the judicial branch is part of the federal government. It cannot be more serious, and you feel it when you walk in. It's a very different world, and you realize that you need to be very careful how you walk in this world.
Yeah, I think as I remember in the Portland District Court, I think above the judge they had like this mural and almost looks like an eye staring at you. It is a little unnerving. I
Yeah.
suspect it's there for that particular reason, but
Yeah, columns, it's marble, I
oh
mean, you walk
yes.
in, and that's the thing to remember too, is the federal government has all the resources. Jesus, at the end of the day, they're the ones printing money, right? They have all the resources. You only have the resources your personal money can buy in your defense counsel or defense team. That's what's so hard about these cases. They've got unlimited resources to throw into the prosecution against you.
Yeah, he's definitely gonna be I know they're coming for him, so they're gonna pay extra special attention.
Yes.
A question though about the pre-sentence report. That doesn't sound like it's a short process. That sounds like it
No.
could take quite a while. On average,
Yeah,
I don't
usually at
want to
least
hold you to
60
it, but how
days.
long?
usually at least 60 days. So you've got the pre-sentence investigation, and then you've got meetings with the court in between. So you've got you've got to usually a meeting with the court prior to putting the plea in. You have to know which judge you're going to be in front of, because each judge has a specific script that they like following in their type of case that you need to make sure you've presented to the client, gone over with them a number of times so they understand what's going to be asked of them. After that, you may have a pre-sentencing meeting between the time of the sentencing and the time that the pre-sentence report is finalized. You may have a meeting in between the pre-sentence investigation and the pre-sentence report. If you're objecting, you may have other meetings to talk about those objections and how they could be resolved. So it could take a number of months, but usually it's about 60 days, 60 to 90 days max from the time the pre-sentence investigation begins until they produce the final report.
Yeah, so this isn't like you're
No, it's not like it's done in a
convicted,
couple of
plea on
weeks.
one day, convicted with a plea or convicted. Now you're being sentenced the same day.
Right.
It's gonna take
And,
a, it's
and
gonna
it
take
could
a while.
go longer because one side or the other may ask for additional time to respond. So you normally have, a set amount of time the court will set for responses for objections. And sometimes as defense attorneys, we may file one or two extensions for that for various reasons,
So it can
and
take a
which is
while.
usually not objected to.
So that leads to a good point. So you're going to be, for most cases, you're not immediately going to jail to await prison sentence. You're going to be out, maybe being monitored, maybe home confinement, but there's an opportunity there for you to do some pretty foolish things. Um,
Yeah. If you're out on bail and you commit a new crime, bye-bye bail, or you decide to run, and the judge always tells you this when you put your plea in, we call that bail jumping. Or after you can be, well, let's go even further. You get sentenced. You can ask for a stay of the execution and an opportunity to self-report, and most judges will let you. Even in like drug cases, they'll let you if you've shown you can behave. But it leaves more opportunity for you to screw things up. I.e., get a new crime, have second thoughts, and decide to run. All of those things will crush you if that's the case.
so I'm assuming usually you're pretty clear with your clients. You are on thin ice. You need to behave during this process. Work with me, keep in touch, but don't do anything that's
Yes,
preventing the
absolutely.
case. Because I know, especially with Thomas Goldstein, there is the allegation that he has worldwide connections, crypto using cryptocurrency, so there may be money hidden in foreign accounts. Who knows? Someone like him, you would be saying, look, you need to be very careful. Anything that looks like the slightest attempt to run, you're going to be slammed.
You're getting yanked, and they're looking at
Yeah.
you hard, 24
Yeah.
7.
Um, I was,
Jim, is it appropriate time for take a pause? Just got to take a 2-minute pause if we may.
yeah, hold on a second. So we've gone through all the sentencing as far as you've got the pre-sentence report, you've got the factors that are considered. One of the things I want to ask you about is we have a community of people who know the defendant who's been convicted or pled guilty. Is there any advantage to having family, friends, colleagues talk to the defense attorney to kind of help with sentencing?
Absolutely. And I don't know that it'll work in Mr. Goldstein's case, but I would just talk about things in a general sense. The answer is yes. But here's the catch. The people that are going to, first of all, if you're going to have letters written on his behalf, it's good to have a mix. You don't need 50 people coming into court at a sentencing hearing to talk about what a great person your client is, or whatever they're going to say. A representative sample, 3, 4, 5, maybe a couple family members, a few people from the community. But what's important is they need to be able to tell the story of how they know, because you would be shocked. I do know that judges have asked, did you know that Mr. Bly was charged with the crime of dot dot dot? And they're like, no, I had no idea. Can you that person, they're whatever they're going to say is meaningless. The judge is not paying attention. So you're the people that write a letter or testify on your client's behalf about why they're a good citizen needs to be able to say that I understand what he's been charged with. He came to me 6 months after the indictment, told me the story. I was shocked, dismayed. That's not what I expected from him. That's very different than my experience with him in the community. I'd like to give you some examples. And I think what's really important for courts that they want to hear is when you come out, and again, Mr. Goldstein's a different situation, but for most people, When they come out of federal court, their ability to make a living is going to be
Yeah.
very difficult. It's going to be very constricted. And how they're received by the community is going to be important to whether or not they're successful. So if the people can also say, and I am going to do everything I can to support him, he'll have a job when he comes back because he was a good employee, or I'll help him get a job, or he's going to stay at my grandmother's house, whatever it is, to give the court some sense that you're going to be embraced by these members of the community, that they're not going to turn their back on you, so that you can be successful when reintegrating, is an important thing for the courts to consider. So it can't just be he's a good person, or
Yeah.
the worst one is, and Donald Trump wasn't indicted or didn't go to jail, so I don't think Bill should go to jail, and this whole thing's a sham. And you can do a lot of damage when you come up and say that. So if you're going to have anyone that's going to say good things about your client, you better have it on a script that you've personally approved. Again, it needs to be their language, their words, but you need to make sure that they're not saying things that can hurt your client, because they could. And you need to make sure they understand what your client was charged with. And you need to make sure that, what did your client tell them? Not just I was charged with, but did they tell them about how this happened? Because the court may ask them, and depending on what your client did or didn't say, may end up hurting your case when it comes to having these people talking on your behalf. So you really have to investigate it. You're like the investigator as a defense attorney, and you're the gatekeeper. You may hear some people and you're like, there's no way I'm letting that person testify. Maybe they can write a letter that we can, mark up. But again, you're putting on evidence to the court. You need to make sure that it's credible evidence before you put them on in front of the court. Same with the letter. I hope I didn't go over too far on that,
No,
but I
no.
just think it's a really good point you brought up, Jim. And it's something that you really have to vet. You should vet at the state level, but you really need to vet it at the federal level, because I have seen judges basically conduct an examination of a person who was not prepared, that was there to testify on behalf of a client. And what they testified to was different than what we represented in our argument and what was in the PSR. And thankfully, the judge believed this person and took that into consideration for a more lenient sentence. But had they not believed this person, they would have and they would have actually used it as an aggravator against our client. He would have gotten a much harsher sentence. So you can't take anything for granted when you're going to sentencing. It could be like the Wild West if you're not really thorough and careful.
Now, like I said, that's why going to the federal court's a lot different animal.
Absolutely.
Final question. I think this is always a good one, because if you have a client, let's say, is convicted or feels the need to plead guilty because the evidence is enough where they could be convicted on it. If they want to appeal to be found innocent, or at least have their case returned for a retrial, how do they walk the dance at sentencing? Because you have, obviously you're going to get hit if you don't accept responsibility. But let's say you have a client who feels that they are in fact innocent. How do they make the dance where they don't essentially admit guilt to something to which they're hoping down the road an appellate court's going to find that they were wrongly convicted, or shouldn't have, been forced to plead. I'm not sure that's probably a good way to say that, but essentially, I know there's some people who innocent, or if maybe feel what they were found guilty of wasn't the full, that was more than they actually did. That's one question I've always been curious as to: how do they walk that fine line?
I don't think you can. You're going to have a judge that's actually going to start questioning you. Uh, you either accept responsibility or you don't, and you better fully accept it, or you don't get the acceptance of responsibility. If you're not prepared to accept responsibility, you can just enter a plea, uh, and maintain your innocence. But I'm pleading guilty because it's in my best interest, and you lose all acceptance of responsibility. But at least you get maybe 1 point credit for early notification of plea. But if everything you're saying is contradicted by the evidence, you may actually, the judge may say, I'm going to take this, I think you lied. I don't believe anything you've said. And I'm going to use this as an aggravating factor in your sentencing. So if you're going to a plea, you need to plea and accept responsibility. Even if you don't agree with everything, you're better off accepting responsibility for it. I don't see any way you can accept responsibility for these things, but not that. Um,
Yeah,
the
I
and the,
have.
here's the thing: the time for arguing about that is the pre-sentence report. Let's just say relevant. We talked earlier, I think before we got on camera, about relevant conduct, and the government can use that. Maybe you're arguing whatever the relevant conduct is didn't apply. The time to argue that and say, I don't agree with that, and lay out your reasons is in the pre-sentence report. Maybe that's where you do it. So
Okay,
that I
so
could see that might be the only way I can, just off the top of my head, I could conceive getting around it to some degree.
yeah, so you really have to listen to your attorney and walk that fine line, because if you're gonna, whether you're convicted or have to or plead, you can't, unless you're somebody who's so stubborn as to continue on that route, you're gonna pay for it. Sometimes it's better to drink your take your medicine and just and go with it.
Let me give you a case example. I had a client in federal court, and uh, we we the explanation that we put out for why the client committed these frauds was never raised in the PSA, and probably should have been left out in our sentencing argument. And we ended up having to withdraw it. We had to tell the court, we are not providing this as an explanation. We don't want the court to rely on it. We don't want the court to consider it. But the victim had seen it, and the victim was angry, and was very angry at sentencing. But the court wanted to know why my client did it. And my client's like, I don't know, what do I say? And I'm trying to cover the mic, and I'm saying, look, you got to tell the truth. She goes, well, I did tell the truth. I'm like, you can't get up there and say. And the judge said, I'm going to assume, Mr. Bly, that if your client speaks about what it is he or she, I'm not going to identify the client,
Yeah.
said, that happened, is not what we have agreed to, is a lie, and not to be accepted by the court. And I said, she said, well, that was, the client said, yeah, that's what happened. I said, you cannot say that. And I had to say, Judge, I'm sorry. My client's not able to provide an explanation at this time, and we're sorry that we can't provide the explanation. And my client just been honest. And what my client had presented was, in hindsight, and sometimes when you get into advocacy, you want to believe what your client says, right? Because otherwise, how can you advocate effectively? But you also have to be objective. And what I could have done was prepare my client for that possibility, because I think if my client had told the truth about why the client had committed these frauds, my client would have avoided jail. And to this day, I'm convinced of it. And my client got a very lenient sentence in light of, and significantly less than what the government looked for. So it was a victory all around. My client could have avoided prison time. I'm sure of it. Had my client been able to tell the truth. But the thing I believe is my client could not be honest with himself, let alone anyone
Yeah.
else at that point. So until my client could actually be honest with themselves about why they did it, how could they be honest with anyone else?
Yeah, and you definitely don't want to perpetuate a fraud or a lie
No,
or because that'll
no. And that's why you have to be so careful in these arguments. Like, you really need to make sure your arguments are supported to at least some degree by what's in the pre-sentence report. And if it's not, you better be able to put some evidence on for the court that's credible to support what it is you're saying now.
yeah. I think
And
everything's
by the way, had we gone the route and insisted on my client's version, it would have been collapsed like a house of cards. This is all I'm having respect. And the government would have sent the FBI agent out to then talk to these other people to find out, is there any evidence to support this? And if there's no evidence to support it, well, the court's gonna just say you lied. Not only, we may not find any evidence to contradict it, but we found no evidence to support what you're saying, and I'm going to give it no credibility, and you just lost acceptance of responsibility. So you have to be very, very careful in sentencing
yeah.
on these
You can
cases.
essentially snatch defeat from the jaws of
Yeah.
victory.
And we
Yeah.
were able to, I mean, we walked a very tight line, but we almost blew ourselves up on a landmine when the client was asked, can you just,
Yeah.
why'd you do it? That's what the court really wanted to know. And that's what the victim wanted to know. So, sometimes you learn things the hard way, but thankfully, my client got a great outcome, but it could have been a stellar outcome if they could just have been honest with themselves to begin with.
Yeah, but unfortunately, at least you defended, I'm sorry, at least you protected them from themselves because it could
To
have
the,
gone
to the extent I,
the
yeah, to
other
the
way.
extent I could, yeah.
Yeah.
And that's also where it's a good thing when you've got a good relationship with the prosecutor, because the prosecutor flagged that issue for me beforehand. And I said, okay, I think we need to have a conference with the judge. And I said, we're not going to use this. This doesn't belong in here. I understand where the government's coming from. Had I had a bad relationship with that U.S. attorney, they would have just waited and sandbagged me with it, and my client would have gotten crushed.
Oh,
And so that's
could
again,
have been
that's where it
worse.
helps to that's where it helps to be agreeable and cooperative to the extent you can as a defense attorney when you're talking about a case that you know is going to ultimately end up in a plea.
Yeah. I mean, the same goes for working with the IRS, just generally the civil side. You get more with honey than you do with vinegar.
Yeah, yeah. If you're going to fight them
Being
on every issue, right, Jim? I'm sure you've seen this in your time. You get someone on the say the state side and they owe taxes, and it could have stayed civil, but they were a jerk to the investigator. They started lying. They
Yeah.
agreed to payment plans, didn't follow through, and finally the investigator goes, you know what, I'm just going to send this to the criminal investigation division. And now we're dealing with I forget the AUSA's. We're dealing with Greg Bernstein, who I like very much, but he's the tax prosecutor for the Attorney General's office, and Greg's a really smart individual. And now you just turned your what was the civil liability into now you're looking at potential jail time or prison time. Just so you can snatch defeat from the jaws of victory by just lying to the investigator, telling them things that they find that telling them things that aren't true, committing to payment plans that you're not going to commit to, and then eventually they just get frustrated and they're like, okay, we're going to forward on for criminal investigation. And I've had that happen with clients. I get involved when now it's a criminal case, but it never needed to go that.
Yeah. This is a funny story. This isn't my case, but you'll appreciate this one. So, uh, firms working with a client to work out a collection case for an attorney in Connecticut, and I think the sticking point was a motorcycle. So the revenue officer wanted this guy to sell the motorcycle, pay over the money to him, and they were just going to close the case. So attorney goes to the client, says, sell the motorcycle. Guy's like, no, it's my motorcycle. I'm not selling it. So attorney goes back to the revenue officer and says, look, he doesn't want to sell. And that kind of blew up the case as far as no deal. And then I think it was 6 months to 6 months or maybe a year later, they're still trying to work it out, fighting about things, and eventually they get a call from the special agents for criminal investigation division for the IRS asking about, did your client tell you about his um, guitars? Apparently, these were not just regular guitars; they were essentially signed, someone signed, artists signed on the guitar their name. And he had this collection. I think it was worth maybe $500,000. Didn't disclose it. But he was so smart, this attorney, he was giving a tour to people who enjoy, fancy guitars, going through his house showing them, and the IRS got a hold of it. And that got referred over for criminal investigation basically because the revenue officer was so pissed off that the guy would just sell the motorcycle and give him the money, he suspected something else was going on. Investigated further, found that, referred it over to criminal, and then went from there.
It's like when you have an audit, sometimes you just want to have things that just give them the easy, the low hanging fruit, just let them have it. Don't fight about it. You don't want this to continue to go further.
Yeah, but didn't. With that, I think we've plumbed the depths of Thomas Goldstein's indictment, at least we could probably go on for hours, but I think that's a good view of the landscape of why when you've got a case like this where there's some suspicion that this could go criminal, doesn't necessarily have to be it's going criminal because that's too late at that point.
Right.
Why you should get a criminal defense attorney involved. Of course, get a tax attorney. Hello, but you want to at least have someone who understands privilege, what to say, what not to say. How does it work as far as a lead up to an indictment and thereon through trial and sentencing? So, Bill, thank you so much. I know I think I was only like, oh well, maybe we'll get this done within 45 minutes, a half an hour. We've gone over an hour, and I really appreciate your time because like I said, Bill is one of the premier members of the Maine Defense Bar. So having him here is a great resource for everybody. So I appreciate your time. And I always joke with people, I hope I never have to call you. So for your services as a criminal
Well,
defense.
sometimes you do. I mean, we have had some cases where you got me involved, and then that's the other thing. You get when you know things are going south with the IRS. I'll just leave the audience with this thought. First call should be to Jim. Jim is, he's got a CPA, he's a tax attorney. This is all he does. Your call should be to Jim. And then Jim's looking at your case going, this might, I can see this going criminal. And then his call is to me or whomever in the criminal defense community he thinks is going to do the best job. And now you're starting to put a team together. And as Jim
Yeah.
said, when you're calling a criminal defense attorney, it's usually you've already been charged. And that is not that it's too late, but you really want to be out in front of this. And so you've got IRS issues, you've got tax problems. They're not going away. You should call someone like Jim, let him help you navigate this. And if there's a thought it could go criminal, that's when Jim calls someone like me. So really that first call's got to be to Jim. That's your best move right out of the gate. So
Yeah,
Jim,
and
thanks for having me. I appreciate it.
no, thank you, Bill, and hey, have a great weekend. And I'm sure I'll have you on again because Thomas Goldstein is going to be the gift that keeps on giving for material. I think there is another case I want to highlight to you that I think you'll really appreciate. But for that, thank you so much, and best of luck this weekend. I know you're going skiing, so don't break a leg.
Absolutely. I'm gonna
Enjoy.
go. Yeah, yeah. We don't joke around with go break a leg. That's never a good luck thing for skiers. I think that applies to something else. But yes, we have a huge storm rolling in. I will be skiing in Saddleback this weekend and enjoying it. I messed up my back last weekend, so this whole week I've been trying to get healthy. So I think I'm
Fingers crossed.
10% away. If I can get just a few more percentiles in the green, I'm going. I'm going regardless, Jim. I'll be up there.
Yeah. Well, enjoy. And
Thank you, Jim. Good to see you.